My name is Tammy McCutcheon. I am chair of the Federal Society's Labor and Employment Practice Group. I'm very proud to be in this position because I took over from a certain new labor secretary, so it's really great to have Jean. And I did want to remind you that Secretary Scalia will be here tomorrow to talk to us at 11:15, so I do really want to encourage you to go hear him speak. That will be in the Grand Ballroom. After that, we are going to if you're interested in the Labor and Employment Practice Group and getting involved, we do have a lunch immediately following hearing from Jean, and that will be in the Hampshire room tomorrow for lunch. Without further ado, let me welcome our panelists and you today to this wonderful topic, arbitration in the Me Too era. Now, our practice group chose this topic because as employment lawyers, we're writing arbitration agreements for our clients all the time, and challenges to arbitration agreements have been winning over and over and over and over again in the Supreme Court, but unfortunately appear to be losing in the court of public opinion in this era of Me Too. If there are law students in the room from Yale, Harvard, or Stanford, students from those law schools are pressuring and sometimes succeeding in forcing big law to give up their arbitration agreements. We've had employers like Google and Facebook announce that they are no longer going to have mandatory arbitration for their employment disputes. So we're here to answer this wonderfully expert panel to answer the question today, what is the future of arbitration in the Me Too age? Now, to introduce our wonderful panelists, we have Judge Jane Larson, who from the United States Court of Appeals on the Sixth Circuit. Her full biography, of course, is in your app, and I'm not going to go through it, but I do want to hit some high points. The most important thing, of course, is that she's a graduate of Northwestern Law, my own law school, and also the law school of another Trump appointee, Judge Brennan, on the Seventh Circuit. Now, Judge Brennan graduated in 1989. You graduated in 1993? I graduated in 1990. I guess President Trump missed my class. Still time. Before she went on the federal bench, she was she served as a clerk on the Michigan Supreme Court. She was a faculty member at the University of Michigan Law School. And I will tell you, I fell in love with you, when I read your article about Justice Scalia in the New York Times. One of your lines in that piece I will never forget and could in fact be a new theme for the Federalist Society. She said, Justice Scalia believed in one simple principle, that law came to the court as is and not as ought. Isn't that great? So with further ado, the floor is yours, Judge Larson, and welcome and thank you.
Hello, and welcome everyone to this panel on arbitration in the #MeToo era. I am told that this is an historic occasion. It is the first time that a National Lawyers Convention panel has included a hashtag in its title. So who says that people who like to hang out with the FedSoc don't keep up with the times? Actually, everybody says that, but whether it's true or not, I will leave to others to judge. We are here actually today to talk about quite an old statute. Congress adopted the Federal Arbitration Act 115 years ago, responding to a perception that courts were unduly hostile to arbitration. Yet far from being a little-used legal antiquity, the FAA has been at the center of at least 24 Supreme Court merits cases since 2006, and its provisions are robustly enforced in the lower courts. Although FAA-governed arbitration clauses can arise in any number of contractual relationships, our focus today is on arbitration agreements in the employment context. Arbitration disputes in employment contracts have recently been headlining, both in our courts and in the news. In its 2017 term, the Supreme Court decided Epic Systems Corporation versus Lewis, upholding arbitration clauses that waive collection action procedures in Fair Labor Standards Act cases. The dissent in that case predicted that the under-enforcement of federal and state statutes designed to advance the well-being of vulnerable workers would be the inevitable result. In response, the House is considering legislation, the Restore Justice for Workers Act, which would render unenforceable any pre-dispute arbitration agreement that requires arbitration of a work dispute. That legislation would abrogate the holding of Epic Systems by invalidating any agreement that requires a worker to promise not to pursue, bring, join, litigate, or support any kind of joint, class, or collective claim arising from or relating to a work dispute in any forum. Quite broad legislation. But contemporary concerns about mandating arbitration for employment disputes appear to go beyond its effects on wages or benefits. The Me Too movement has also raised questions about confidentiality and non-disclosure, especially when required of victims of sexual assault or sexual harassment. In response to such concerns, law students have advocated for law firms to stop requiring summer associates to sign agreements requiring the arbitration of employee-related disputes, and that advocacy has expanded to encourage the abandonment of such agreements for all employees. Earlier this year, Harvard Law School required all firms recruiting at the law school to disclose their mandatory arbitration policies. And I am told that women's groups from 8 highly ranked law schools pledged not to accept any funds from law firms who used mandatory arbitration agreements for any of their employees. In the face of changes in culture and potential changes in the law, we are here today to discuss what the future might hold for mandatory arbitration. What are the costs of workplace arbitration, and are there benefits that are getting lost in the shuffle? With me for this discussion, we have a truly exemplary panel. You have longer bios of all of these gentlemen in your apps and in your programs, so I will be brief. In fact, they are so accomplished that if I weren't brief, our hour and a half would be over before I sat down. So I will keep it short. We have first the Honorable Paul D. Clement. Paul is a partner at the Washington, D.C. office of Kirkland & Ellis, and as you all know, served as the 43rd Solicitor General of the United States from June 2005 to June 2008. Before his confirmation as Solicitor General, he served as acting Solicitor General for nearly a year and as Principal Deputy Solicitor General for more than 3 years. He has argued more than 95 cases in the U.S. Supreme Court, including most relevantly for this panel, Epic Systems Corporation versus Lewis. Next, we will hear from Professor Alexander J.S. Colvin. Professor Colvin is the Kenneth F. Kahn Dean and Martin F. Scheinman Professor of Conflict Resolution at the Industrial and Labor Relations School at Cornell University. He is also an associate member of the Cornell Law School faculty. His research and writing, well, I'm going to tell you what it is. It focuses on employment disputes with a particular emphasis on procedures in non-union workplaces and the effect of the legal environment on organizations. Next, we will actually hear from Mr. Deepak Gupta. Mr. Gupta is the founding principal at Gupta Wessler PLLC. He focuses on Supreme Court appellate and complex litigation, covering a wide range of issues, including constitutional law, class actions, and consumer and workers' rights. Mr. Gupta regularly appears in the Supreme Court and in appellate courts nationwide. In the 2016-17 term, his firm was counsel of record for parties in 3 merits cases, and he was lead counsel in 2, and he prevailed in both. Finally, we have Mr. Andrew J. Pincus. Mr. Pincus is a partner at Mayer Brown LLP, where he focuses his appellate practice on briefing and arguing cases in the Supreme Court and in federal and state appellate courts. developing legal strategy for trial courts, and presenting policy and legal arguments to Congress, state legislatures, and regulating agencies. He is a former Assistant Solicitor General in the U.S. Department of Justice. He also founded and serves as the director of the Yale Law School Supreme Court Advocacy Clinic. So with this fine panel, I am sure that we will have a robust discussion. The panelists have all told me that they can keep their introductory remarks to 5 minutes. We will see. But I promise to bang the gavel not too long after the 5-minute mark. We will then follow up with a chance for the panelists to respond to each other, either with rebuttal, with questions, with comments, and I hope to get a discussion going there. And then if time permits, we will open it to the floor so that we can get some questions from all of you. So with that, I will first give you Paul Clement.
Silence your cell phones on cue. No, that was great. Thank you. So thank you, Judge. It's great to be on this panel with these distinguished colleagues, and it's particularly great to have you moderate this panel for us. So thank you for doing it. Just like a Scalia clerk, to start with the statute, the FAA. You know, we could have an hour-and-a-half long discussion about arbitration without mentioning the statute, but that would just be wrong. So that's a great place to start. And I'll follow up then and just talk a little bit about kind of what the Supreme Court typically does with cases that arise under the FAA. And I am going to try to keep this quite short, and I really am going to kind of just try to set the table here, because as Tammy said in her introduction, you know, this is kind of like a tale of kind of, you know, two sort of temperaments towards arbitration. The Supreme Court seems to be very favorable to arbitration right now, but in part because of the #MeToo movement, the public perception of arbitration is a little different from, say, a majority of the court's perception. In terms of the Supreme Court and arbitration, until last term, kind of my stock description of the Supreme Court and arbitration was there were two kinds of arbitration cases in the Supreme Court. There were cases where the party seeking to enforce an arbitration agreement won 9-0, and then there were the cases where the party seeking to enforce the arbitration agreement won 5-4. But there really weren't any cases where the party seeking to enforce the arbitration agreement actually lost. And, you know, I learned that, you know, the hard way, along with Deepak in a case where I was trying to get the court to not enforce an arbitration agreement, and came up with 4 votes and a rousing opinion in favor of the 4 votes, but came up a vote short. And I think that really was the story in almost all these cases. The exception was last term, where the court finally, in New Prime against Oliveira, found a case where they actually didn't accept the employer's argument for enforcing an arbitration agreement and not allowing an individual to sue. But in a sense, I think this is the classic exception that proves the rule, because the issue there arose under a codicil or a caveat in the FAA that carves out, and since it's a statute, and Jones here, Judge Larson's here, I'll quote it, so I'm not paraphrasing. You know, the judges don't like it when you paraphrase statutes. So I'll quote it. Contracts of employment of seamen, railroad employees, or other classes of worker engaged in foreign or interstate commerce are essentially accepted from the scope of the FAA. And so the argument by the employer in this case was a trucking firm, so it was squarely within the carve-out clause, but they said, but we can still enforce our arbitration agreement because this particular trucker is an independent contractor and not an employee. That's a tough argument, and it got exactly 0 votes. But that's the kind of argument you have to make to lose in the Supreme Court when you're trying to argue in favor of arbitration. A much more typical case is the case that I argued a couple of terms ago that Judge Larson alluded to, which is the Epic against Lewis case. In that case, a 5-justice majority in an opinion written by Justice Gorsuch rejected the argument that Section 7 of the National Labor Relations Act created essentially an exception to arbitration agreements for collective action. The argument in that case, which under the Obama administration the Labor Board had accepted, was that you could have employment disputes be arbitrated, but you couldn't enforce a class action waiver provision in an arbitration agreement because the NLRA gave special protection to collective action on behalf of the employees. The court, as I say, in a 5-4 decision, it rejected the board's position, accepted the argument that you could have arbitration of employment disputes and enforce the class action waiver. And the one thing I'll say about that, so I keep within a standard deviation of the 5 minutes here, is to say that probably the most striking thing about the EPIC decision was the dissenting opinion by Justice Ginsburg. She donned her dissenting collar, went on to the Supreme Court bench the day the EPIC case was handed down, and really read her dissent from the bench and gave a kind of stirring cry that Congress might want to revisit what the majority of her colleagues had just wrought in interpreting the FAA to essentially trump the NLRA. And to my mind, it was kind of reminiscent of her dissent in the Ledbetter case, which led to the Lilly Ledbetter Act and the Fair Pay Act. And so I do think, she was quite deliberate in picking this case and this topic as a case to make a kind of a dissent from the bench and a call to Congress to action. So I think it sets the stage well enough that the court loves arbitration agreements, sometimes for dissenters not so much, and I'll leave it to the others to talk about the rest of public opinion.
All right, thank you. Professor Colvin.
Great, thanks very much. I'm going to be talking a little about what we know from an empirical perspective about what's going on in arbitration. I just want to hit some of the highlights of the statistical analysis that has been going on to try and get a picture of what do we know about this phenomenon. And it's a phenomenon that we actually didn't know a lot about until fairly recently, I would say. And part of that reflects, I think, something that we see in the title of this session, the confluence of mandatory arbitration and the Me Too movement, right, over the last couple of years when we've got this increased attention to sexual harassment cases, but then also this is a period when arbitration has sort of expanded both in its impact across workplaces and also in the public realm. There was a 2016 New York Times series on mandatory arbitration, which is the first time I think that it got that level of attention in the mainstream media. So a few basic things that we've been able to figure out. Firstly, the question of how widespread is the usage of mandatory arbitration in employment context. That was something that hadn't been very clear. I did a few studies on this about 20 years ago, where it seemed about 15 or 20% of the non-union workforce was covered. That actually seemed to stagnate through most of the 2000s and early 2010s. So if you look at the American Arbitration Association case filings, there are about 1,000 cases from really about 2000 to 2013. And so that suggests that there really hadn't been an increase in adoption by employers. However, if you look 2013 onwards to the present, you get a dramatic growth from about 1,000 cases a year to about 3,000 cases a year. That could be increased filing activity, but it's probably much more likely that's an increased adoption by employers. So a couple of years ago, to try and get a hard number on this, I did a nationwide survey of establishments, employer establishments, to see how widespread adoption was. And from a sample size of just over 600 employers, we found 53% had adopted mandatory arbitration for their non-union employees. Tend to be larger employers, so that's about 56% of the non-union workforce, which corresponds to about 60 million employees. We do have some evidence that larger employers are more likely. There was a separate study done trying to enumerate Fortune 100 companies that had cases enforcing arbitration, and found 66 out of 100 had enforced agreements to arbitrate. So widespread usage, most non-union employees now, and particularly amongst larger organizations. What do we know about cases that are actually being brought in arbitration? So one of the basics process-wise is how long is it taking? Research we've found is that it takes on average about a year to a hearing. 361 days was the number that we found in a sort of long, 11-year long sample of all the American Arbitration Association cases. That compares to litigation. The standard stats we see, federal courts about 2 years, just over 700 days on average to resolution after a hearing, 723 days in state court. So we're seeing about a sort of 2-to-1 ratio, 1 year versus 2 years to resolve. Settlement numbers, some recent research suggesting that the difference is less dramatic in settlement cases that are settled. How much is it costing? Always an interesting question, particularly if you're paying the arbitrator's fees. So if your client's paying the arbitrator fees. So we find across the American Arbitration Association cases, average of a little over $11,000 per case for cases resolved after hearings. Overall, across all cases, $6,000 per case. Most cases are settled in arbitration, and the arbitrator fees in the settled cases tend to be $4,000 to $5,000 on average. So not insubstantial for settled cases. What are the outcomes of arbitration? So this is something that's actually trickier to find out than it might seem because there's a few complicating factors, and there were some mistakes made in some of the studies in this. One classic one was mixing together individually negotiated arbitration cases and mentor arbitration cases. If you have an executive client who's negotiated as part of an executive contract with the employer arbitration, those are handled differently by the AAA, and they have very different sets of outcomes. If you mix the two together, you're going to get mixed up statistics on that. There's also some problems in some litigation studies mixing together things like putting in summary judgment cases with dispositions after trial. One of the classic mistakes on that is putting in dispositions after summary judgment, because a disposition after summary judgment is only going to be included if it's a successful summary judgment, because in the statistics they don't include it as a disposition if a summary judgment is denied. So you skew the numbers against the plaintiff success rate if you put in the summary judgment ones lumped in together. So what do we find overall? So the studies find about 20% of employees are successful in arbitration. That compares to about 36% in federal courts, 57% in state courts. If I'm representing an employer, my least favorite place to be should be state court, in the middle on federal court, and I'm better off in arbitration. The same pattern holds in damages. So median damages in arbitration, about $36,000, half the cases larger, half the cases lower, $150,000 in federal courts, close to $300,000 in California state courts. So California state courts are probably where you'd least like to be if you're representing an employer. One of the big questions around arbitration is accessibility. There are some arguments that it'll increase accessibility. We're not actually seeing that in the data. So the couple of stats that are relevant. We see about 3,000 cases a year filed in the American Arbitration Association. We've got some survey data indicating that about half of all arbitrations are through the AAA. That suggests around 6,000 cases totally filed in the country. In litigation, it's not as clear because you have to aggregate across state courts. Probably 75 to 100,000 cases filed per year in litigation in the courts. So if you think about equal number of employees under mentor arbitration and under mentor arbitration, it looks like about a 10-to-1 difference in terms of the filing rate, which is supported by some of the surveys that we've done looking at plaintiff attorneys who tend to view the damages they can get in arbitration as making it not worth them bringing cases unless they're really strong cases, right? Now, there's two different implications of that from policy versus practice. The policy argument around, does this suggest arbitration is problematic because it's reducing access? From a practice standpoint, if I was an employer counsel, this suggests that I'm doing something economically rational in advising my clients to use mentor arbitration agreements, right? Sort of the revealed preference that we see from an economic standpoint of employers adopting this seems to be a rational preference. This is what I would say to a defense counsel they should be doing based on the numbers, because the numbers suggest they are going to do better in employment arbitration. And in large part, this is going to have an effect through plaintiff attorneys not being willing to take cases. When I present these numbers in conferences with a lot of plaintiff attorneys, they tend to think, oh, okay, the numbers suggest there's something problematic with mentor arbitration. They get excited, and then they start doing calculations that come up quiet to me to afterwards and say, are you sure on those numbers? And I say, I'm pretty sure the numbers. They're like, because I'm not going to make any money on cases with these numbers, so I'm not going to take the cases, right? And that seems to be the plaintiff attorney's reaction there. So I think that's kind of underlying a lot of the debate that we're seeing currently about arbitration. So I'll conclude my comments there and pass on.
Very good, thank you. I think next we are going to hear from Deepak Gupta. No?
I think we were going to do me next.
Oh, I have well, it's a good thing that we have the panel here because the moderator has it wrong.
Sorry.
So, all right, Andrew Pincus will speak to us next.
So I think my role is to talk a little bit about the policy debate, and I guess I'll start by saying, arbitration doesn't have a natural defender. Lawyers, we all learn about the legal system in law school, and you sort of see it as this wonderful due process model. Maybe you have some experience with it, and you become a little skeptical, but most lawyers are pretty comfortable with litigation in court. I think both plaintiff and defense lawyers have a lot of, not quite the heebie-jeebies, but a little worry about arbitration because it's a very different animal with a different set of rules. So my hypothesis is even though arbitration doesn't have a natural PR proponent, it's worth digging under some of the stories that you've heard because actually it does pretty well. And it could do even better, I think, if there was an effort to actually popularize it rather than demonize it. And I think that's really one of my big takeaways from spending a lot of time both looking at arbitration from a litigation perspective and from a public policy perspective is, I think for the reason that Professor Colvin talked about, arbitration is a natural place to go for smaller individualized claims that really are not, as a practical matter, litigable in court because the amount at issue is not going to attract a lawyer, and you really can't litigate in court without a lawyer. Arbitration, on the other hand, is a pretty user-friendly method. The AAA lets you file online. You can choose to have a telephone conference. You can choose to have your case resolved on the papers. You can have a real conference if you want. But in terms of empowering people to pursue their own claims when they're maybe not attractive to the legal system, it's a pretty powerful device. And so my sort of starting point is, much as lawyers love litigation, we should recognize that it has its flaws and that there may be, for large quantities of claims, a better way to resolve disputes. And I think that's what arbitration does. Let me step back for a minute and talk a little bit about the procedures, because I think since we're in #MeToo mode, one question that naturally arises is, does an arbitration put a gag rule on claimants? Doesn't it stop people from talking about their claims, which would be a pretty terrible thing? And the answer that the courts give is no. If an arbitration agreement tries to silence you, that arbitration agreement is going to be invalid as unconscionable. If an arbitration agreement tries to stop you from talking about the outcome of the case, that arbitration agreement is going to be invalidated as unconscionable. So the notion that arbitration necessarily means that claims can be hushed up is just not right. It is possible that some of the executive agreements that Professor Colvin referred to, maybe in that unique situation where you have someone who has access to high-level company information, a clause might be enforced. But for the kind of arbitration agreements we're talking about here, which is really general agreements that cover wide ranges of employees, the courts just won't allow it. And the other thing is states require the publication of outcomes in arbitration. California and Maryland require that the AAA and other arbitral providers post results on their website, which actually enables some of the analysis that people couldn't do before. So it's a valuable thing all around. So I think it's important to separate the sort of arbitral process from questions about gag rules and other things, which I really think are a totally separate world. The other thing people sometimes talk about arbitration is, isn't it a rigged casino? Aren't there these arbitration agreements that require you to waive punitive damages? Or impose very short statutes of limitations, or basically say the company's general counsel will either be the arbiter or pick the arbiter. There too, as the law has developed and the Supreme Court has blessed the application of general unconscionability principles to arbitration agreements, those kinds of provisions get knocked out. And what you have most companies doing is going to either the AAA or JAMS, both of which have due process protocols that apply. If you want the AAA to arbitrate your employment disputes, you're going to have to abide by a series of requirements, including, for example, that the employee can't be required to pay more than a couple $100, with the employer paying the rest of the cost of the arbitration. So I don't want to go too far over my 5 minutes, but I guess my starting point is we should try to get underneath in the public policy debate, which, as Paul said, is very different from the debate about enforceability of the FAA, get behind some of the demonization of arbitration and talk about how it really works, because it's quite a different thing.
All right, thank you very much. And now we will hear from Deepak Gupta.
Well, I want to thank the Federalist Society for taking notice of the way that the conversation around forced arbitration has changed as a result of the Me Too movement. It's an important conversation to have, and I want to thank Judge Larson for moderating the panel and from saving this from being what the kids call a manel, because that wouldn't be a great look, I think, when you're talking about the Me Too movement in particular. So just to set the stage for the policy conversation, I think it's important to talk about what we're debating, what we're not debating. We're not debating the merits in this policy conversation of whether arbitration or alternative dispute resolution can be a good thing, whether that should be permissible. The question instead is whether it should be forced onto people who have no realistic choice, or whether it should be optional. And so in circumstances where alternative dispute resolution makes sense and the virtues of it are obvious to parties who are informed, they would be able to opt into it, even if the legislation that is now making its way through Congress were enacted, even if the broadest legislation that Judge Larson described were enacted. So instead, the question is, should people who take a job at a big box retailer, low-wage workers, people who are using products and services where there isn't really any choice to avoid arbitration, should that choice be available? Should there be legislation to stop that? And when you poll Americans on that question, overwhelming majorities of Republicans, Democrats, and independents, over 80%, believe that it should be a choice, that they should not be forced into a private corporate system when they have a claim against their bank or against their employer. And since the theme of the Federalist Society convention this year is originalism, I think it's worth really stepping back and taking a moment to think about what the framers may have thought about the state of affairs that we find ourselves in. Recall that when the framers left the Constitutional Convention in Philadelphia, they had worked out a compromise, but they didn't have a Bill of Rights. And one of the chief critiques of the Constitution was the lack of the Bill of Rights. But it wasn't just the lack of a Bill of Rights. It was, in particular, the absence of the Anglo-American civil jury trial right that led to the Bill of Rights. So the founders thought that was a precious right, the ability to access court, a public court, the kind with all the due process stuff we learn about in law school. They thought that was important, so important that they put it in the Constitution. And with other constitutional rights, if there's going to be a waiver of those constitutional rights, of course you can waive your First Amendment right, your Fifth Amendment right, your Sixth Amendment right. The law is that we require that there is a knowing, voluntary, and intelligent waiver, and we impose pretty strict standards to ensure that there's such a waiver. And so it is worth asking why this state of affairs that we find ourselves in, where there's a wholesale exit from the civil justice system that the founders guaranteed, why that is consistent with our founding ideals. I also think it's worth asking how we got here when we look at the original intent of the Federal Arbitration Act. And I can't get into all of this. There's too much to talk about, and there are oceans of law review articles on this. But what the Supreme Court has done is something more akin to common law adjudication, an accumulation of precedents that has kind of created, as Justice O'Connor put it, an edifice of the court's own creation in the guise of statutory interpretation. Paul read you Section 1 of the Federal Arbitration Act. And if you just read that text with nothing else, unaccompanied by any of the case law, you would think that the people who wrote this statute did not intend it to apply to workers. That's what they said in the legislative history, but for those of you in the room who only like to look at the text says that. And so we've really departed quite a long way away from the original intent of the statute. Justice Thomas has been a lone champion for, I think, the correct view that the statute was never intended to apply outside of federal court. It was intended to be a purely procedural vehicle in federal court and not apply to state court. But this statute has kind of metastasized into this preemptive beast that preempts all state law that's in the way. And so the states are really unavailable. It's unavailable to them to fix the problem, even though they've enacted some legislation in response to Me Too in New York and California. I think it's fair to predict that legislation is going to be struck down as preempted by the Federal Arbitration Act. And so that creates a lot of pressure on Congress to do something about it. And this year, for the first time, legislation that would exempt consumer and employee claims from forced arbitration passed the House of Representatives. And you may think, well, it's dead on arrival in the Senate. But there's a vote that I don't think most people noticed that happened early in the Trump administration over the Consumer Financial Protection Bureau's rule that would have banned arbitration clauses that had class action bans in the consumer context. And interestingly, that vote, which required just a simple majority under the Congressional Review Act, was so close, and there were Republican votes in favor of the Consumer Bureau's rule, that it required the vice president to break the tie. So the politics of this are shifting. There are senators like Lindsey Graham, Jody Ernst, and others that are concerned that the jurisprudence of forced arbitration has just gone too far. And I think the Me Too movement has highlighted that, but it is not the only context in which people are concerned about this. It sweeps across the whole broad range of potential civil claims that could be brought. Wage and hour law, for example. If a legislature passes a wage and hour law and gives a private right of action, and the only way of meaningfully enforcing that law is through class litigation, which it is. It's just not sensible to litigate or bring those claims on an individual basis. Then the enforceability of arbitration clauses in the employment context is tantamount to a nullification of that law. One way of thinking about it is that corporations are writing laws in the fine print of contracts for consumers and employees that are trumping the laws written by the legislature on behalf of the people. And that really is, for a wide swath of claims, what's happening. So to put that all together, forced arbitration is inconsistent with our shared constitutional values, our founding ideals. The way it operates now is inconsistent with the original intent of the people who wrote the Federal Arbitration Act. It has the effect of nullifying legislation enacted by the legislatures. And it ends up killing claims. It ends up, we like to think that it's going to this other place with arbitrators deciding the cases. But for the classable claims, for the claims that only exist if they can be classable, the claims just die altogether. And the best evidence of that is the Consumer Financial Protection Bureau's study, which looked at the American Arbitration Association to see all of the claims within their jurisdiction. And they found that over a 2-year period, the number of consumers, and I realize we're talking about workers, but I think a similar thing happens for workers' claims that are classable. The number of consumers that achieved affirmative relief on claims of $1,000 or less, guess how many it was? It wasn't 400,000 people or 40,000 people or 400 people. It was 4 people. 4 people got relief. So it's not a better, cheaper, faster system to which the claims go. It's just the primary effect is to kill claims altogether. And I commend, for those of you who are interested in this, Brian Fitzpatrick's new book, The Conservative Case for Class Actions, which was written in response to the Supreme Court's arbitration jurisprudence and makes an argument from conservative principles that this jurisprudence has gone too far and that we should all, conservatives and liberals, be concerned about where this has gone.
All right, thank you. I see Andy over there scribbling notes, which is good. That suggests that we're going to have some back and forth here. People have some things to say. So I guess we don't have a particular order in which to do a rebuttal. We can go in reverse order back, or Paul, if you want to start, or.
I think Andy is dying.
Yeah, I think so too.
Dying.
So let's
yeah.
so let's let him go first, and we'll work our way around the table this way.
Thank you. I don't want to lose control. So I really think it's worth stepping back from the judicial system versus arbitration. This is about how are we going to resolve people's disputes. It's wonderful to talk about the Seventh Amendment and the jury right. How many people actually get to the place where they have a jury trial in federal court? An infinitesimal number. A lot of the protections that federal courts provide are illusory in that they are never motivated. And what happens is this wonderful system that we've constructed is basically a system that provides leverage to various sides to settle the dispute, which is what happens to the vast majority of disputes in arbitration and in federal court. So to me, maybe this is I'm not an economist by any means, but let's look at whether we can construct a system that's actually better at doing that than the federal court system is, in that it gives more people the ability to get their claims heard, or at least to initiate a process that will lead to getting a legitimate claim vindicated, as opposed to the federal court system where, let's face it, we lawyers are gatekeepers. On the plaintiff's side, it's plaintiff's lawyers. They're understandably want to earn a living, and so they're looking at what kinds of cases are going to earn them the most living. And those may be a very small slice of cases that real people care about. One of the things that we did in connection with thinking about the Consumer Financial Protection Bureau rule that Deepak mentioned was to say, what kinds of claims do consumers care about? And the CFPB actually set up a public database. So we took a random sample of the claims that actual consumers had put into a database, and it won't surprise you to learn that most of them were not the kinds of claims that you see in class actions. They were about my bill, my interest rate, my credit report, and wanting to get things corrected. And those are the archetypal kinds of claims that are never, ever, ever going to get into court. So to me, the question is, how do we look at systems in terms of providing the most justice for the most people? And what happens in arbitration, again, it's largely still a system for creating incentives on both sides for settlement, but the incentives are very different starting at the beginning. As I said, in both the consumer and the employment context, the company has to pay the lion's share of the fees, and right up front, the company has to pay about $1,000 or some odd fee to get the arbitration started. The AAA and JAMS and sort of the conventional arbitration providers limit the fees that have to be paid. So if you're a company and someone comes to you and says, we have a beef, we're going to file an arbitration, it's sort of a no-brainer to say that the arbitration system that the company has agreed to gives that employee or that consumer significant leverage to get a settlement before the arbitration is even started. And in fact, this is what happened. I argued a case called AT&T against Concepcion that dealt with the question of class waivers in the consumer context. And AT&T decided that what it wanted to do was to construct a dispute resolution system that paid less money to lawyers, including Mayor Brown, and used more of the money to settle disputes with its customers so they would be happy and actually stay as customers, which is what most companies want. So they constructed a system that said, for small claims, now up to claims under $75,000, we, AT&T, will pay all the fees, as long as the claim isn't Rule 11 frivolous. Come to us first. There's a mediation step. Come to us first. We will give you a settlement offer. That may make you happy. If you decide to go to arbitration, we will pay the fees. If in arbitration you get a penny more than what we offered you in settlement, we will give you a minimum payment of $10,000, pay double your attorney's fees, and pay all of your expert costs. What's the purpose of that? The purpose of that is to give AT&T, self-inflicted, an incentive to say, we are going to settle all but the most crazy claims, because that's a good system that makes our customers happy and takes all the money that we would spend defending class actions, paying law firms, like probably many other people in this room, and puts it into resolving claims with our customers. So when Justice Scalia, who I sort of trust on the meaning of the FAA, wrote the opinion for the court in Concepcion, he said, quoting some findings of the lower courts, that there was no doubt that AT&T's system provided quicker, surer relief for injured consumers than the class action system. And that's what AT&T tried to construct. I think it's a very important and viable system. And even Justice Kagan, in writing the dissent that Paul likes in the Amex case, said we don't need class actions to vindicate small claims. There are lots of other ways to do it, and one way to do it in the arbitration system is to say, if you're a lawyer, you can say, I want to represent all of a company's customers or employees on some claim, set up a website in today's world where people can sign you up, and you then have the ability to file claims that will inflict a lot of economic pain on the company. And probably, if the claim is legitimate, bring the company to the table, but there's a big difference between arbitration and class actions. If the company thinks it's right, it doesn't have to roll the dice on some gigantic verdict in order to get a merits decision. It can say, you know what, we're going to arbitrate the first claim and see what happens, and maybe the second and the third. And if the company starts to lose, my guess is it'll start to settle all those cases. And if the company starts to win, maybe the lawyer will say, maybe these cases aren't worth too much. But unlike the court system, where class action settlements virtually never turn on underlying merits, right? Because it's all about motions to dismiss and class certification. At least you have a system that gets somebody to look at the underlying merits of the claim, which I think is really important. I'd say a lot more things, but I'll yield for the moment.
All right, thank you. Professor Colvin, do you have some remarks?
Maybe just on this, on the accessibility question, because I think that is the best policy argument in favor of arbitration, right, is that if a system could provide greater accessibility to justice and get to merits of claims, right, I think that is a strong argument. I think from the empirical standpoint, when we look at, we don't see that yet in the current system, right? And so I think that's one of the tensions here, right? We see fewer claims than we would expect if they're great accessibility. It's, you know, a tenth or so of the numbers we'd expect to see. Which in one sense, you know, helps explain why it's been adopted. I mean, one thing I find when you talk to the executives who are considering their counsel's advice to adopt mandatory arbitration, one of the worries is it's going to produce a flood of claims, right? The flood of claims argument, I think, is one of the barriers to adopting it. But I think they've been convinced there aren't a flood of claims because we don't see the flood of claims. You know, and it's, you know, the question is sort of what's going on there. You know, one stat that may suggest something there is we don't actually see a lot of self-represented people. It's just under a quarter of the people in arbitration, similarly to litigation, are self-represented. They do terribly like they do in litigation. Self-represented people do terribly in all legal forums. It's one of those easy wins if you're an empirical researcher. Self-represented people always, you find that effect. Claims, not a lot of smaller claims. 3/4 of the claims are over $60,000. So we don't actually see a lot of the smaller claims. And I think part of that is the inability to get lawyers to represent people bringing claims. That's going on there. There's also a bit of an issue, which we haven't really touched as much on yet, but I think there has been a growing complexity of arbitration. I did a research exercise once where we read through a whole year's worth of AAA arbitration files and looking at the whole case file, and they're surprisingly thick files now. This took a lot more of my research assistant's work than I had planned because they look a lot more like a federal or state court file in terms of motion practice. Summary judgments were there in half the cases, and a lot of complexity, which has increased. If we wanted to do a more sort of open, accessible system, you could imagine designing a different kind of arbitration system where it was sort of simplified and more supplemental to the courts. One thing I've written about is sort of a more radical suggestion of adopting the British rule, which is where you can choose as the plaintiff to file in either the employment tribunal or in court, and that's the plaintiff's election. They're stuck with whichever one they go with. There's no double dipping, but you get your choice there. And you could imagine sort of setting up a sort of generally available arbitration system if people want to use that, or you could go to the courts if you have a bigger, more complex claim. The thing that would make this only a public policy solution is I suggest this should be the plaintiff's election, not the defendant's election, which is the current model. But I think if we're designing a public policy system, you could come up with a way to use arbitration to have more accessibility. We just don't see it in the current system yet.
So just a couple of thoughts from me. I think Andy started off by saying that arbitration has no natural defender. And Deepak makes a pretty good case against arbitration, so I guess I would say thank God for Andy. He may be unnatural, but he's a very good defender of arbitration. I will say, just from personal experience, I did an amicus brief in support of Andy's client in the Concepcion case, so I actually had occasion to read the arbitration agreement that Andy, I think, worked with AT&T to formulate, and based on my relatively objective reading, I thought that was so favorable to the complainant that I wanted to go out and file a complaint, even though I was a Verizon customer, because I thought I had a decent chance of getting 10 grand. I mean, it really was. And there's a serious point there, though, which is, not all arbitration agreements are created equal, and particularly in the consumer context. I mean, I'm sure there were a lot of non-litigation reasons why AT&T wanted to write that favorable sort of agreement, but I think it probably served them very well in the Supreme Court when the court was looking at it, because that was an agreement that really made arbitration a real possibility, it seemed like anyways, and that's the last thing I'll turn to in a minute. I just wanted to sort of make a point about, I think, especially as you move from the courts being general pro-arbitration, but you think about some of the numbers that Deepak alluded to about, if you pull arbitration, it depends how you ask the question, of course, but if you pull it, it doesn't sound like something that's like super popular. And I do think that, it's probably important in thinking about these issues to disaggregate some of the sub-issues that are here, because one thing is the issue about arbitration, the other thing is the issue about sort of gag rules and the like, and then the other issue is, are we talking about class arbitration? If we don't have arbitration, what are the alternatives? I think those are all things that it's worth disaggregating. I mean, I think a good illustration of that is Deepak makes an excellent point that, when in the framing generation, the Seventh Amendment was something that the framers took very seriously. But of course, the framers also thought the proceedings at the Constitutional Convention should be confidential. So they had a different view about sort of confidentiality than they did about the Seventh Amendment, and it may be, particularly if you're a fan of arbitration, it may be that the best way to keep arbitration through the #MeToo era is to disaggregate the two issues, decouple the two issues, and essentially say, look, gag orders or non-disclosure in this context may be a problem, but it's not, you don't have to get rid of arbitration to get rid of those non-disclosure provisions. And, so it may be important, if you like arbitration, to actually make clear that there are multiple issues that are really going on here. The last thing I would say, and this is one thing I want to, actually agree with Deepak on, and not just because it was a theme of the brief we wrote together, but I do think there's, in having this public policy debate, there's a big difference if the debate is really a choice between arbitration and nothing, or whether it's a choice between arbitration and litigation. I think reasonable minds can disagree about sort of the virtues of arbitration versus litigation if that's the relevant choice. But if you start talking about claims where the choice is, if you're going to have arbitration agreements, that the claims really aren't going to be brought, then I do think you have to have sort of a second order discussion about, some claims aren't brought because they're not claims that we really want to be brought in our system if they're not worth it to the claimant or the claimant's lawyer. Other claims are claims we very much want to be brought, notwithstanding the fact that if you just leave it to the incentives of the lawyers, they probably won't get brought. And then, there are ways of incentivizing those claims to be brought. And, there's a whole bunch of them, and I can think of, class actions is one way to get those claims to be brought. Another is punitive damages. Another is statutory damages. Now, all three of those, based on my personal experience just representing defendants, can lead to some, pretty sort of unfair settlements in claims where the underlying claim really isn't all that great because just, if you're facing a relatively sort of livable settlement versus the kind of possibility that you're going to get really whacked, in a class action or with punitive damages, a lot of defendants will decide the right thing to do is to just settle. And so, but I think you can't be against everything. And so that's why I think the way Deepak puts the issue is the right way to think about the issue. And if there are claims where, they may not be brought if there isn't some incentive to bring them, then I think that, we ought to have an intelligent policy discussion about how do we get those claims brought and maybe avoid some of the kind of disincentives where you create a system where the claims settle without having anything to do with the merits. I'm no expert on this. One thing that occurs to me, though, is you could have sort of like one-sided attorney's fee shifting where, if the defendant loses, the defendant pays the plaintiff's attorney's fees, but not vice versa. That has the virtue to me of addressing, a very real problem, but at the same time, that seems like something, a defendant ought to be able to do without saying, I'm going to settle this claim just because I can't afford to take the risk of class actions with statutory damages or the possibility of punitives. That's a risk that's worth running that might make the system work better. But I think, especially for those that like arbitration, I do think it's important to take sort of Deepak's point very seriously and be prepared to be in favor of something. Because I think because I do think it's a tough position. If you're really going to say that if you don't allow class arbitration, if you don't allow class actions, because you allow them to be in the arbitration system instead as individual claims, if they're claims, particularly claims under the civil rights laws, you need to be able to offer something that assures people that those claims are going to get brought. Otherwise, I think you may lose the public policy debate.
All right, and we're going to allow Deepak because you didn't get the chance for your second round. So,
and then we're going to have to go around again, don't you think?
Well, I mean, I don't know. It depends.
We can let these people.
Depends how we go. Yeah.
Well, I'm really I'm glad to see that this discussion has already generated some agreement, and I think that you see why Paul is such a great advocate. He takes apart the problem, and I think he's right to disaggregate the problem. It's hard to talk about this as a one-size-fits-all solution, and I think there is a very active debate going on about the world where it's arbitration, where arbitration is really killing claims, where nothing is left as a result of an enforceable arbitration clause. And I think Paul's right. That is increasingly difficult to defend. At the same time, this often devolves into a debate about the civil justice system more broadly and what people see as the pathologies of class actions. And again, just to plug Brian Fitzpatrick's fantastic book, he mentioned some of this. And
Are you getting a fee for that?
He's not giving me a commission. But it's just come out, and I think this is the audience for that book. And he talks about some of what Paul is talking about how you can, at the back end, there are ways to tweak the way the class action device and the way the civil justice system works, rather than throwing the baby out with the bathwater, which is, I think, what the court has effectively done with some of these cases. It's interesting, our positions seem to line up based on the cases that we've handled in the Supreme Court. I also argued the AT&T versus Concepcion case, and I have a little bit of a different view. I mean, I think Paul is right that Andy and his team did a fantastic job in designing an arbitration clause that looked like the perfect arbitration clause. But I also think he's right that that was principally for the Supreme Court's consumption. The dialogue, when you're writing these clauses, is not between the corporation and the worker or the consumer. The dialogue is between the corporation writing the clauses and the courts that are going to decide whether those clauses are enforceable. And the Supreme Court in the Concepcion case made much of the features of the clause in the facts section, but the reasoning of the decision sweeps much more broadly than that. And what it then gives a green light for corporations to do is to design clauses that are much worse and are nevertheless rendered enforceable. And so it's the shadiest industries, industries like the payday lending industry, that have the highest prevalence of arbitration clauses, where they have business models that are illegal and they depend on exiting the civil justice system in order to make this happen. So we have the cases where it's, arbitration is being used to exit the civil justice system and there's no claim at all. And then there's also a conversation about individual claims where people really do have the wherewithal to go to court for those individual claims and they want to. And I think what the Me Too movement has teed up is a really serious conversation that we should all ask ourselves. Do we really think it is okay that somebody who has been a victim of sexual assault, for example, cannot bring that claim to a public proceeding in court and exercise all of the rights that people, I think, take for granted? And that is, I think it's a very difficult position to defend, the idea that those people should not even have the choice to go to court for those claims. And that, I think we're going to see the politics of that shifting. I think that that's an area where people on the left and the right can agree, and I think we're going to see legislation about that. I'll just, and I hope I'm not going too far over my time, I just want to give one anecdote of a case that I learned about recently. A woman, her name is Lily, and she doesn't use the last name to protect her identity, went to a massage parlor. It's a chain of massage parlors called Massage Envy, and she was sexually assaulted there. And she did all the things that you're supposed to do to try to address the problem. She reported it to the police. She tried to exercise her rights. And to add insult to injury, the company was still charging her for her membership to this company. And it's like a gym membership. So she tried to cancel, and she couldn't cancel. And we've all had that experience, sometimes really hard to cancel services. And they told her the only way to cancel is download the app to your phone and you can cancel the membership. So she did that. And when she downloaded the app and canceled, which she was able to do, she also unknowingly agreed to a forced arbitration clause that precluded her from going to court to vindicate her claim arising out of that sexual assault. Now, I think I can tell that story to this room and to the American Constitution Society and to a lot of rooms, and I heard people, you react viscerally to that. So I think that is why I think I'm optimistic that there's going to be some change as a result of the Me Too movement, at least in this area.
Okay, any further response from our panelists to each other about?
I mean, I could talk about this all day, but.
So one question that I had for you, Andy, is tying it back to what we see coming out of the law schools, and we see the law schools demanding that the law firms, if they're going to recruit on campus, that they not engage in mandatory arbitration, either for summer associates or for associates more broadly. What you say suggests that those concerns, which I think arise a lot out of the confidentiality concerns, are really illusory because courts will strike them down anyway. If that's true, I guess I'm wondering, why are the students agitating? So it could be they're misinformed, it could be their professors are telling them arbitration is just bad in general, so you should just be mad about it. Or it could be that there's something real to the claim that they're trying to vindicate. So I'd like to hear what your thoughts are about that.
Well, I think there certainly is a belief out there, as Paul said, that all of these things go together, right? Gag rule arbitration, gag rules, rigged decision makers, waivers of some elements of your claim. I think there's a belief that somehow arbitration authorizes all those things, and the law is to the contrary. But I think it has become a sort of a rallying cry, and that's the nature of a movement. I mean, I do think what's interesting about that development is it sort of shows the power of technology today to allow people to band together, and that's why I actually don't think this is not just the general counsel of the company and his or her lawyer deciding what the arbitration clause is. I mean, AT&T did this for a number of reasons, but it also wanted to have a clause that it could go to its customers and say, here's a clause that we've generated that we think is a very fair deal. And I think in today's marketplace, that's a really important thing for companies to talk about. So when I talk to general counsels or other people at companies about drafting an arbitration clause, I say to them, this will become an issue of public debate. And if you want to sort of have the clause that has the most minimal things that you can possibly get away with in order to and still have your clause enforceable under the FAA, you have to recognize that you may pay a public price for this, the same way companies do about all kinds of other clauses in their form contracts. So I think to some extent, law firms are the entities that least want to pick a fight with law students. So I think once it happened, it was sort of like, let's get rid of this clause and not have a discussion that puts us on the defensive in defending arbitration. But I do think there is a discussion to be had on that. But I also think, to Deepak's point, a smart company will think hard about its arbitration clause because it doesn't just have to defend it in court, it has to defend it in the court of public opinion, and I think that's something really important for lawyers to think about.
Deepak?
So I want to stick up for the students I admire these students. It's a group of students. It started at Harvard Law School and it's now spread to law schools across the country. I don't think they're misinformed. I think those of you who practice know that the background assumption that is enforced every day is that arbitral proceedings are confidential. So arbitration is a vehicle for, among other things, creating secrecy around claims of sexual harassment, sexual assault, and all sorts of other claims. And that is one of the problems. It's not the only problem, but it's one of the problems with forced arbitration. And the Me Too movement has made that abundantly clear, that these clauses have been used. Now, I mean, Paul's right. We have to be careful about being clear about the issues. There are separate non-disclosure agreements that can be enforced, and that's a separate conversation. But there's also the issue of arbitral confidentiality. And so, in a way, arbitral confidentiality is worse because it's not like a non-disclosure agreement that's negotiated where somebody has some leverage because they could go to court and they settle and they agree not to disclose the information. It's like a non-disclosure agreement at the beginning of the case, which protects all of the proceedings. And I don't have the same confidence that Andy does that courts are willy-nilly going to strike these things down as unconscionable. And that, of course, requires somebody to hire a lawyer and mount a challenge like that. So I think the students are right to point out that this is a problem, and they realized that actually the law firms are very sensitive. They need the supply of these students from elite law schools, and so these students actually have some power. They assembled information about which of the firms had these clauses and pressured them to drop the clauses, and now there are just some holdouts, but most of the large law firms are dropping these clauses. A similar thing happened with Google engineers. You may have seen that there was a scandal at Google involving a high-level executive who had committed sexual assaults, and Google workers around the world walked out in a coordinated walkout, and their chief demand was that Google drop forced arbitration clauses in their contracts. And the tech companies have done this. They've now started dropping these clauses. So you have these two groups of elite workers, students at the top law schools and engineers at places like Google, who are able to agitate to get these clauses dropped. That's not going to work if you are working at a poultry factory in Iowa. So it highlights the problem, and it shows that well-informed people with a lot of market power can make a change here. But I don't think it's a solution to a substitute for a policy solution.
Anything from this side of the table?
No, I guess I would just add, though, I do think some of the, the examples with Google and with the students, I mean, it does show sort of the dangers about sort of not disaggregating all of the issues. We've talked about sort of non-disclosure and confidentiality versus the substance of this. The other thing is, there was a long period of time in the Supreme Court's arbitration jurisprudence where you generally enforced arbitration agreements, but you didn't apply them to federal statutes. And then there was a time where you, sort of applied them to maybe a couple of commercial statutes, but you wouldn't apply them, or at least there was an argument that a lot of circuits had bought, that you wouldn't apply them to federal anti-discrimination statutes. And by the time it was all said and done, the Supreme Court made clear, no, there's no exception for federal statutes, and unless the federal statute is expressly clear and basically says this trumps the FAA, then you don't have an exception for even federal anti-discrimination statutes. And in a weird way, I think some of the pressure that's being brought to bear is almost a product of the fact that the Supreme Court went all the way to say that, yes, the pro-arbitration policy applies even in the context of federal anti-discrimination statutes. And I sort of wonder, if it might be prudent for some employers to proactively sort of, overrule Gilmer and whatever the other couple of cases that said that, the FAA applies to anti-discrimination statutes. Because I think if you took the anti-discrimination statutes essentially off the table and said, no, they're different. I mean, everybody's got their own hierarchy of federal statutes that, both from what they think are important to enforce, but also from a PR perspective would be problematic to say aren't going to be enforced in court. But I do think this debate would be a little bit different if you basically said, oh, no, like, we would never, we carve out Title VII from our arbitration agreements because just as a policy matter, we don't, the Supreme Court says we can have them extend that far, but we don't want to. I think that would definitely change the policy debate. It's my sense, anyways.
Professor Colvin, anything?
I agree with that last point that I think it would change the debate. There is something different about, I think, Title VII and the sexual harassment cases. I mean, I think one of the interesting political moments a few years ago was the Franken Amendment to the Defense Appropriations Bill that barred defense contractors from requiring arbitration, from enforcing arbitration clauses in sexual harassment, sexual assault, gender discrimination cases. It didn't extend further, but it actually got through Congress. It got support from, I believe, all female Republican senators supported that bill. And so it was interesting, the saliency of the kind of Me Too related claims, which I do think have a different saliency than your routine wage and hour claim.
All right, well, we have about 15 minutes left, and I want to make sure that we have a little bit of time for questions from the audience. So I don't want to cut off our panel discussion, but it's always good to hear from you, and I know you probably have some questions for our panelists. So if there are questions from the audience, if you could go to a microphone, that is helpful. Although I don't know if people are moving to a microphone or just leaving the room. Okay. They're like, oh, good, I can get up now and stretch my legs.
And this is probably directed at Professor Colvin. As we discussed beforehand, arbitration has been a central part of every collective bargaining agreement since when? Decades and decades and decades. And has never brought up this negative reaction to arbitration and seems to have worked within the union management context. And Professor Colvin or others, where does the union arbitration processes play into this discussion, if at all?
Yeah, I think it's a great point because it does show that it's not arbitration per se that is the concern here. I mean, labor arbitration is remarkably stable in over a period of time when unionization's declined, the nature of collective bargaining has shifted, that the labor arbitration system essentially has stayed the same for over a half century. It's almost 100% of agreements include labor arbitration. It's a robust thing. Why is that? I mean, I think it's a couple of characteristics, right? One, it's genuinely bilaterally negotiated and bilaterally administered. I think that's fundamental to why it's successful. I think, the fact that the alternative is industrial conflict, right? The alternative, if you think back to the days of sort of Britain of the 60s and 70s of kind of wildcat strikes all the time, right? That's something that has been a powerful argument for arbitration. I think it's also the case that it's because it's part of an integrated system in the workplace, grievance procedures, and then you get to arbitration. So it is fundamentally kind of a different system design, but I mean, it shows that you can design systems involving arbitration that can be effective in the workplace. For all the concerns about forced arbitration, right? That doesn't mean that the litigation system is a good system for routine employment cases, right? I think it's an excellent system for certain kinds of civil rights cases, but for routine employment cases, we do have a fundamental problem that the amount in dispute is often not enough for a really complex system. What do you do with a person who lost $10,000 or $20,000, right? I mean, I think that is a valid and important public policy concern.
I think this just quickly reinforces the first point that I made, which is the debate is not about, whether arbitration in the abstract can be useful, can be a good thing. Of course, it can be, if it's chosen by the parties and really negotiated, as it is in the labor context, or it is when two oil companies decide they want to resolve their disputes through arbitration rather than litigation. So, I think it's just a completely different beast from a situation where nobody has any real choice and they're being foisted out of the civil justice system against their will and without their knowledge.
Okay, another question.
Hi, Mike Doherty from Atlanta. And forgive me if I missed this entire point while I was out answering a call. But last year there was a fantastic a panel about how few cases get to court, and the general public doesn't understand this, and what they really are driven for is to be heard by a jury of their peers. So when you are starting a job and wanting money to survive, and somehow sort of will say anything, and it's Google, or a big law firm, and so you're supposed to sign that to get the job, that's not the really right time for the battle for arbitration, and then you're thrust in later, and I think that's a sort of a proactive vigilante, like, no, I want to be in front of my peers, and I don't know the law, and I've never had this experience, so that's where I think the problem is, and I don't know if you address that or not, but I think that's sort of the core of the American public wants to be heard by their peers, not ground down by some sort of mountain climb of litigation process, whether it's in court or arbitration. Well, the question is, what do you think about that?
I mean, as I said, this may have been when you were on the phone. I think part of the problem that we have here is, we don't have a great litigation system that works for the kinds of people that you're talking about. And so, one question is there a way to do something better? Because the civil litigation system is a very, very flawed beast, whether it's for the individual claims that really never get in the door, or even for the claims that get in the door that are mostly not, if they're big, as Paul said, they're not really going to be resolved by anybody looking at them on the merits, let alone a jury. You don't even get a judge looking at them on the merits in any way, and that's I think it's just a very significant problem with the way the system works. And we could have a much longer panel on whether there would be ways to change that system to make it more merits-based. But that requires lawyers. We've constructed a system that if you had infinite money and infinite time would get so many facts on the table and you probably would get to a very reasonable result. The problem is no one has infinite money and infinite time.
Or attention.
And lawyers have been, or judges and lawyers who construct the system have been very unwilling to tolerate shortcuts that, yeah, sure, in some case might not yield the sort of maximally rational result, but in the range of cases might, and that's a really different discussion about how to structure dispute resolution.
Probably a great thing for next year. Thank you. Sorry if I made you repeat yourself, but to me it's like vigilante employee pitchforks. Thank you.
Pepper Crutcher, Balch and Bingham. I've been management employment lawyer for almost 40 years, and in my experience, the only way if you're an employee who's got a claim in arbitration, you don't get paid is if you don't get paid because you lost after a hearing on the merits. The number I expected to hear you say, you didn't say, which is, in what percentage of arbitration cases do you get a hearing on the merits?
So the settlement rate, right? I mean, that's the kind of filtering out is about sort of 70% in litigation and arbitration, right? So both cases. I mean, I think Victor said this. That is, you're mostly in settlement mode in both modes, but obviously you're settling in the shadow of the hearing, whether it's litigation or arbitration, right? We know that rational settlements in the shadow of hearings. In terms of I think one thing you're alluding to is the question about the summary judgment impact, right? Which traditionally has been sort of one of the differences, the idea that arbitration you'll get to a merit hearing, whereas you'll get the summary judgment hearing. You'll get to summary judgment, but not to a merit hearing in litigation. It's certainly the case that there's more summary judgment in litigation than arbitration, though the gap is narrowing as summary judgments increased. When I looked at it 5 years ago, it was half. I'm assuming it's greater now because I had previously looked at it was like 20%, and then it was 50%. I assume it's higher than 50% now if the trajectory continues on. The other thing I think that complicates things a little bit is that summary judgment, right, now is the crucial thing affecting then the settlement process, right? We've got pretty good evidence, which may be a sort of obvious point, that settlement behavior changes after the summary judgment. So if you make a summary judgment and lose summary judgment, right, that doesn't mean the case goes to trial, right? It usually means that the case is being settled on more favorable terms to the plaintiff, right? And so even in litigation, right, there's a complex interaction between the levels going on.
So we just don't
Although
know.
I
We
was
just
just
don't
gonna-
know the number. So if it's 1 or 2 cases out of 100 in court that get tried, we don't know whether it's 5 or 10 or 15 in arbitration that get tried?
No. So some sort of hearing is about 20% of the cases in arbitration. So it's about 70% are settled and 10% withdrawn or dismissed, usually non-payment of fees, and then another 20% are a hearing. Of those, that's a mixture of sort of full hearings versus some are summary judgments in arbitration too.
Thank you.
Yeah.
But there are very few in arbitration. There's almost no motion to dismiss practice. So that's a large chunk often of court cases that are thrown out, usually because the claimant is losing, that you don't have in arbitration. So that's a large number of cases that move forward into the system and contribute to the fact that there is more sort of merits-based decision-making. And the other thing I would just say about arbitration is, especially in this era where you have this fee burden on employers, one of the pieces of evidence that we put in Concepcion, for example, was that because of the fee promise made by AT&T, about $1 billion a year in claim payments to claimants happened before anybody filed an arbitration. And so with companies that have and most clauses do have a tell us your claims so we can mediate before you go to arbitration, a very large number of claims are disposed of then because the company doesn't want to then have to fork over the arbitration fees.
Which we haven't got to yet, which is the Wild West currently of the class claims, where the rational response from the plaintiff side class action lawyer is, okay, I'm going to file 1,000 individual claims, and those fees you're going to pay the 1,000 things. And that's a total mess right now.
It's a mess, but, to some extent, this sort of goes with Paul's, if you're going to have an arbitration system, there may be pluses and there may be minuses.
The problem is it's really hard to just make claims go away. They're going to find a way to pop up somehow.
All right, this is probably our last question.
It'll be a brief one. My name's Matt Hank. I defend employers at Littler Mendelsohn. My question's directed to Mr. Gupta. Sir, you directed most of your fire toward mandatory arbitration agreements. Would the existence of an opt-out provision assuage your concerns? And if not, would you be kind enough to elaborate why?
Sure.
Thank you.
I think it would depend a lot on the design. If what you're saying is that, and you sometimes see this, Particularly, you saw clauses that were drafted in order to try to address procedural unconscionability arguments, where the consumer, for example, I haven't seen this as much in the employment context, but the consumer would have a certain number of days to opt out of the arbitration clause at the beginning, after the contract is signed. And what you would expect to find is what you find, which is virtually nobody does that. And that's because at the time someone's entering into a contract or they're taking a job, dispute resolution is not really salient to them. They're thinking about, how much does this thing cost? How much am I going to get paid for my job? What are the terms of my job? They're not thinking about what is going to happen if I'm, sexually harassed or discriminated against or whatever. And so I don't think that's really an answer. But I do think if what you mean is, you could have a system where people can opt in at the time of a dispute or choose to go to court, I'm perfectly fine with that. And that's the point I made at the very outset, which is, I don't think there's really a real policy debate about whether arbitration should be available as an option. It can be a great option in many cases. It's just that people should have the choice.
Yeah, and from the company's perspective, obviously, if part of the sort of rationale of taking on the burden of paying fees, and there will be more claims, you're certainly opening the door to more claims, what you're doing is trying to take the litigation costs, the defense costs you'd incur in the civil justice, in the court system, and use that as the way you're going to pay for the additional burdens you have in arbitration. So if the answer is you have both, most companies that I know would say, if you're going to tell me that I have to allow a choice, I'm not going to have an arbitration system, because that sort of means I'm going to pay twice. So that's unfortunately that the reality is it's a sort of a false choice.
So what I hear overall is that everyone is in agreement that we need some kind of cheaper, faster, easier civil dispute resolution system, and none of us in this room have quite been able to come up with it yet. But hopefully the members of the Labor and Employment group here and others on the panel can put their heads together, come up with that utopian solution. We've had a lot of really great discussion here today. I thank all of our panelists for being here, and thank the audience for your questions and your attention. And I think with that, we are adjourned.